all the parties are citing, kindly check and recheck whether they have any application in the facts of the case. Is one difference in fact. I have not been able to find out any case where a similar fact has come up before the court. Therefore, all the academic exercises that you make may not be an aid to your lordship. But I believe not for that proposition, your lordship does not need any citation, therefore, is this. And another thing, what is 76 Supreme Court? I know, but this is so well known a proposition. My lord, having practiced for so many years and as a judge for so many years, must have dealt with this judgment a number of times. Now, therefore, I don't cite this case, but I make the proposition. Secondly,
in the facts of this case, whatever the judgment cited, whatever the arguments advanced, it may sound academically very attractive, but in the present fact, these are no application.
No application. Secondly, my lord,
yes,
Lord, I adopt the arguments of Lord Advocate General as also of Mr. Patro. I don't repeat. Therefore, my lord, those are to be taken as my submission also. Now, Lord, let us forget about all decisions and submissions. Kindly look at the fact situation of this case. An interview was, a written examination was held. Interview was held. Then, my lord, final list of candidates was published, and a wait list was also published. Now, my lord, two states. Written notes, written arguments, written examination, all these are written. And then if you succeed there, then you come to interview. Now, the writ petitioners did not cross the first barrier. Did not cross the first barrier. Therefore, what happens in all subsequent stages really will not recede to the background. And creation of supernumerary post is undoubtedly a subsequent event. If you had missed the bus at that point of time on written examination, you are out of the fray. So you don't have any grievance to ventilate. This is to be borne in mind in my very respectful submission before your lordship takes any decision on this question. Now, if your lordship sees what is the impact of it, those in the final list, merit list, they have already been appointed. Then what is the purpose of this list of candidates who are called wait-listed candidates? The purpose is to have a reserve source wherefrom, in case of necessity, candidates can be found. Supposing, Lord, for example, of the selected candidates, 10 do not turn up. Where from do I get this 10? From the wait list. So wait list is really a reservoir of eligible candidates. Petitioners are not in the reservoir. Under no circumstances can they be pulled for the purpose of doing this. Therefore, the purpose of wait list will be lost if wait list has no significance in that way. Now the question is, for filling up of declared vacancies only. If supernumerary posts are created, I shall go to that question, whether it can be created, how it can be created, I shall go to that question. Assuming for argument's sake that supernumerary posts have been rightly created. Now for that, when the reservoir is there, whether I can draw persons from that reservoir. There's no other reason for not candidates from this reservoir. Therefore, in my respectful submission, if the creation of supernumerary post is upheld by your lordship, then there is nothing wrong in taking persons from the weightless, given the circumstances. Now, it can be looked at from other angles also. Petitioners complain, look here, this supernumerary posts were not advertised. He did not get a chance to complete. Chance to complete at the first stage. You can't complain that I could not get the chance. Supposing Lord supernumerary posts are dispatched, and from weightless candidates all are available, then do I have to go to those candidates not made it either to the main list or to the list? Now, my lord, argument is very interesting. As usual with Mr. Vikas Ranjan Bhatt, he has his own ways of looking at problems and posing it. I have my greatest of regards for him. Therefore, I say a argument which I have to answer. He said, kindly see, if these were advertised, if the vacancies, supernumerary posts created, were advertised and were filled up in the due process, giving another written examination, interview, etc., then I might have got it. Therefore, my chance to claim those vacancies is not given to me. That's arbitrary. That's violative of Article 14. But look at it from another angle. If, this is, kindly remember this is very important for the case. 2016 examination.
Yes. SLST 2016.
Now, my lord, on 2026. Now, my lord, at that point of time, 22, 6 years had already passed then. Then, my lord, if a process of selection is started in the way suggested by Mr. Bhattacharya, what else? What happens? These persons not only can join the fray, but not those who are not eligible in 1916 will also come. So, you are inviting new applications of newer persons. But now this is 2026, 25 and 26. One might be overaged, so far as these waitlisted candidates are concerned. Some who did not pass the examination in 2016 will also be there. Will that be in consonance with Article 14 is the question. Those who are ineligible at the point of time of creation of this post will participate. Article 14, I am subject to correction by your lordship. I have never seen or come across any case which says a person who did not have the right at the initiation can complain on the ground of Article 14. Therefore, my lord, As is my practice, Lord, I shut my eyes and see the whole picture. What is what? And when I see that, I find that these persons were ineligible in 2016. These persons were ineligible in 2022 when the posts were created. Now the process has started. These persons will also join fray, number one. And number two is the persons who are waitlisted. Many of them may lose opportunity because of no fault of theirs. They may be overaged. And in fact, in this case, I was trying to find out where they are. When, my lord, in the process of filling up supernumerary posts, Service Commission gave us recommendation. We were to go to the school and get the appointment letters only. At that point of time, an order of injunction was passed. So we stopped one place which is ultimate stage could not come because of an order of the court. And my lord, I'll submit that as a result of the order of the court, no one can suffer any prejudice. If he is otherwise entitled, now one person gets a recommendation for the Service Commission. The natural course is he has to go and collect the appointment letter from the school. That stage is not there. Now, everyone knows, and your Lordship's court has held, that once you get the recommendation letter, they are bound, the school authorities are bound to issue appointment letters. So, Lord, many have left their earlier job that they were doing because now that they are getting the recommendation letter, there is no reason to be anxious anymore. We have given up the job and come. Now, if it is said, look here, the supernumerary posts were not created in accordance with law. What will be the fate of those persons? Does Article 14 apply to them also? If so, they will be deprived of an opportunity which they had otherwise.
Yes.
So, but I also feel that no citation is necessary for the proposition that no one can suffer for the action or inaction of the court. Therefore, we cannot say that since there is an order of the court, I give up my job on the basis of recommended. This honorable court has held that once recommendation is there, the school authority is bound to give appointment letter. So I knew my appointment is certain. So I leave my job. Come here.
Yes, sir.
Secondly, persons who may not have lost by leave their job. There are persons who plan for the future on the basis of this. Today or tomorrow I'm going to get it. Recommendations are already there. Now, what happens to them? What happens to them? All these years have passed. They may have a child of 2 years, 3 years. there will be no milk available to them. Because the parents would not understand that even after getting the recommendation, they won't get that job. They won't get the letter of. I believe not. This is violative of Article 21 of the Constitution. Right to life. Right to life means right to live in a humanly way. They will be thrown out. Now, look at it from another angle. But I was just trying to see, without going to niceties of case laws, there are in the notes, but not, I won't trouble your lordship with those. But the first training that I got is forget about law. Look at the facts, and purpose is to do justice.
That you have started with.
But question is, justice does not necessarily mean injustice to another. If there are competing interests, then whether a qualified person should be sacrificed for the persons who became ineligible after the written test. Whether at their behest, nobody has come to say, look here, this supernumerary posts were created, they were not advertised. I could otherwise have done so. They have taken it from the pool of waitlisted candidates. No. No has come. Who have come? Who applied, participated in the written test, failed there, and therefore not called for interview and other things, subsequent steps, they have come. That's a vital difference in fact, where this court's indulgence, my lord, we always say before I read court, it's a court of equity. So, Lord, kindly have compassion, feeling for them. Lord, court of equity, no doubt. But all that we have learned all these years are equity follows the law. Equity does not destroy the law. Equity does not go against the law. Equity cannot override law.
Yes.
To quote the expression that we have learned, fish follows the water. Same way, equity follows the law. And Lord, finally, before I go to any other aspect, my Lord, Justice Krishna Iyer had quoted in a Supreme Court judgment reported in year 80 Supreme Court. Whenever you are in doubt, think of the face of the poorest man that you have come across. Think what benefit is going to get by the order you propose to pass. Think of the face of those hapless persons, toiling for months and years with the expectation of getting a job. And after 10 years, if they are to be told, bye-bye, new advertisement, new selection, those who are not even eligible when you applied will compete. And you out of the competition because you have crossed the age bar, because of very many reasons for which you are not to be faulted. But in my very respectful submission, subject to your lordship feels that this will itself be inequitable. Because balance is there. One side, I fully appreciate, my lord, this sympathetic mind that your lordship has. That is why we always come before your lordship. Something, sympathetic consideration may be done. But even your lordship, with all this sympathy, never directed do something contrary to law. Here also, my respectful submission is, kindly do not do anything which will be inequitable to those persons who have for the examination
already recommended for appointment.
Now, my lord, now, Lord, coming to the supernumerary post, that's the troubling point. May I have the privilege of drawing your lordship's attention to the writ petition of the petition of the original. Prayer. Lord, kindly come to the prayer. What I do is, the first prayer A,
Page 21.
21. On writ of, or in the nature of mandamus issue, commanding the respondents, their agents, and subordinates to provide your petitioners with their original waiver sheet. Possibly, my lord, your lordship is not being troubled with that. Because original waiver sheet is not to be retained after 10 years. Anyway, if your lordship wants, last 10 minutes.
10 মিনিট কেন একটু 20 মিনিট 30 মিনিট তো চাপ
Lordship না করে চাপাই দিন।
চলো চলো
I-
আপনি যদি না চালাতে পারেন তাহলে আমরা কোথায় চলে যাবো বলুন তো? That reputation he has not earned.
That reputation he has not earned. বুঝেছো? That ঠিক করে।
ওসব গ্যাস খেয়ে ছাড়বেন না আপনি আপনি যেটা আজকে করুন please
Now, Lord,
don't try to accommodate him. You can, you do it. I have learned it from him. Neither you can, Mr. Bandhavadda, I know you, you cannot stress the point. If I ask you the repeatedly same question, you will be out of your mind. So I know how to put it. But tomorrow you say don't adopt. Then B, production of the original waiver.
next, commanding the respondent with agencies to provide and publish to read our message. The lordship is not also concerned with this. We are not,
CBI investigation.
we are not concerned. Terminate all the illegal appointments recommended by West Bengal Solution, and thereafter discuss the entire panel. So, Lord, we are going to the root, entire panel. Those in the main panel, those in the wait list, everyone goes. Lord, are the parties to the option? Can this prayer be placed? But we are not possibly here on that. Finally, the respondent to the service. You can send a citizen's side positive notification dated 19th May. And subsequent notification dated 14th October 2020. So this is really the prayer which we have. And we are then certiorari records. These are all. Therefore, I shall have
You are today before me because of the prayer F.
Yes. So I'm limiting the scope of my arguments only to Prayer. I received these two orders. 19th May 2022. That's creating. That's creating.
Page 300. Oh, I'm hearing it so long. Not that.
Kindness. Object. Filling up of preliminary reports of assistant teachers, including such and such, such and such. Not kindly say what is the subject matter of challenge, as we say. 19th May and 14th October. This is a proposal of sent to the state cabinet for creation of supernumerary reports of assistant teachers, including the Calcutta. Look. Next is, what do you in future? This is an non-technical rules for absorption of such various candidates in the proposed supernumerary rules. Both are subject matter for consideration. Okay. It's a cabinet order. Now, therefore, we recite upon one for understanding the governor can please to create 6 months and non-teachers. That's this. One. For absorbing the witness candidates in a supernumerary post so created as per the word. In exchange of powers, the governor is further pleased to write that appointment letters to such witness candidates should be issued in terms of the recommendation of the Commercial Commission in strict compliance with these statutes, etc. Therefore, supernumerary post is created. And why is it being created? And only thing remains is the EC, as far as this is concerned. So as creation of supernumerary post is concerned, that has been created by this. 2022, 19th May. And it has been challenged on 15th November 2020. You let the ball roll, do all subsequent steps. You have no chance otherwise. And then wait to see whether you are having any remote chance. When you find out this is only for the witness candidates, I'm out of it. I is the next order. Two orders.
14th October 22.
Next.
302.
30. For filling out supernumerary post management details, including physical education and population. In the organized schools, it is government and department counseling process for assistant teachers of quality admission and physical education. For the weighted candidates, first level selection, state examination, test for the recruitment of assistant teachers, physical education, according to the
This is a counseling notice.
So, in the first stage, they cannot cross. They can't have any objection to the council. If the creation of supernumerary post is all right, if the decision be absorbed, this witness candidate is all right, then no complaint can be made.
Against this on notification.
Therefore, we are really confined to 1 hour.
19th May.
Nothing else. Oh. Here, only one thing. I'm grateful to my friend. Yes. Refresh my memory. It speaks of section 19
Of the 97 Act.
And she too will change for the Board of Superintendents of Confirmation. Does it restrict the court for judging the validity of this notification going beyond these sections? Because the source of power must be there. What you mention in the order is irrelevant. They could not have mentioned any provision at all. Concretely. If the question is asked, under what authority? Yes, we found out from the statute. Or from that. But this is not. Can we have a look at page Article 162 of the Constitution? Once. I have almost completed. If this Constitution put an embargo, the executive power is to extent the matters with respect to which the legislature of the state had power to make laws. Lord has not been argued before the adoption. The even state could not make any law.
No, that is not.
Therefore, if the state can make a law, then this is shall extend to the matters with respect to the legislature. If the legislature has power to make, then executive also can do it. And when the argument is not that the legislature does not have any power.
No, of course, executive action is immune if it is within the parameters of 162.
Therefore, the executive power is coextensive with that. And that having not been questioned, there will be executive. It's one thing to say, power is there. It's another thing to say that power has been exercised. That's all.
It's the other part of the evidence. You have power, but you have exercised it.
You have power at the end of it, for which purpose supernumerary post is being created. decision of the government is final. The Lordship remembers the Supreme Court judgment. It says,
Before you go to that, I have some queries, but I have gone through your written notes. So I have some doubts, and I will be asking 2-3 questions from your written notes. Now, what you are saying, it is the executive power exercise immunity is given under ones. If you have power, you have not questioned it unless it is LFID. It is always open for the subject to judicial review if the power is shown to be exercised in a manner which is not sanctified by any provision of the Constitution.
No, subject to correction. All the powers are subject to provisions of the Constitution.
Exactly.
If the Constitution says you cannot do it, then you cannot do it. The Constitution did not say you won't do it. Absence of any provision with regard to this does not stand in the way of the executive. So we don't have to search for the authority. Subject to means you can do anything except what is prohibited, not permitted. Therefore, that is what was troubling your Lordship, I believe. That I think what happened.
Yes. Very, very nice point of putting it in that way. Yes. So just one question, I will not be troubling you. That exactly, please come to page 8, point number 30.
Yes. Constitution, the previous Constitution enacted to reach parliamentary reports. In exercise of powers to make policy decisions, and mere omission to put such source of power in the impute notification does not invalidate.
Without seeing your notes, you have argued this point now, just now. Now come to B.
Yes. However, the notification does not mention any specific portion of law, save and except section 19 for the law.
So according to you, need not.
Need not. I could not have mentioned any provisions. I can't. If what you say under what provision, I would satisfy. Yes, whether I have power or not. If I have power, I create. Mentioning of a wrong provision will not invalidate.
Certainly not. Certainly not.
So, failure of me to put a relevant section will also not invalidate.
Now, please come to the 31.
Yes, sir. Executive power and we resorted to take care of special situations when such a situation is not
How far it can be stretched?
immediately to the lordship.
How far it can be stretched?
Special situations can never be defined.
Certainly not.
Therefore, the elasticity has been mentioned and given to combat any situation that is not used. And see, special situations. What is meant by special situations? It's not usual situation. It's a normal situation. Therefore, it's a special situation. Can you see the language? When such a situation is not contemplated in the relevant legislation, but legislature would not have thought. Well,
So don't that special situation. Supposing a situation prevailing, how far this executive power can be stretched?
but if the situation appears to the executive to be special and such assessment is not perverse, but every day it happens. Why you call it special?
Were they not minded to look into the restrictions of constitution?
If there is any restriction in the constitution, yes. If I say, my lord, there is no prohibition in the constitution, then, my lord, what will search for enabling provision in the constitution. Your lordship will have to search for prohibitory provision in the constitution.
No, every enabling, it is not necessary that every action should be enabled by any particular provision.
Therefore, in this
The
case,
start should be whether there is any provision or prohibition or not.
that's right. If there is no prohibition, then what executive has the power? If the state has power to legislate, I have not been able to come across any provision which speaks of prohibition in respect of the executive. It's all pervasive. Wherever legislature can do it, executive can also do it. But I have my notes, along with my notes, given a list.
Judgments and judgments, copy of the judgments.
No, only one. But may I just read out and give it to us.
Which one?
This is, I give you an option. This is Sharad Kumar Singh.
This is in your compilation?
No. Your lordship has put this question. There is an answer to this question here.
Reports kindly give me the.
Calcutta 2020, Calcutta 252.
এই বইটা ইয়েটা দেখি give me 1 second এটা তো বলো তো না বলো চট করে বার করতে বলো শুনে না Sir, 1 minute. Let me have it. AIR 2020 Calcutta 252. Online I don't prefer. AIR much better. Maybe old habit die hard. They are developing with the SCC online. SCC online or others. Because we used to gather the, as you have taught us to see that, no, of course, we cannot deny it, that get an idea. Maybe sometimes the head note is very misleading, but get a minimum idea, then started reading. But in SSC online, that advantage you will not be getting.
just by their demonstration. They will also sing. But they have told us, I was hearing a High Court proceeding from the Pradesh High Court. Let me tell you, furious. Where have you done this type of activity? No, but for me, you are seniority bomb. If we have done something else,
Yes, whatever we do, you cannot avoid your responsibility.
just I should content notice. Please, kindly do it. But I can't change the position. So, look, this is like I said.
This is always once a defendant in a suit died, the plaintiff is not aware of who is the legal heirs. Then it's very difficult situation. Eviction suit, if it is some heirs are not brought in, it will be abated. Then I asked Mr. Dagduka what to do. He casually said, give some names. But correct the address. It will go and they will come and say, it is not my name, but this is my name. But I cannot say as a judge. One, I told him, take this, learn it from the seniors, how to handle.
We all learn from our seniors. And also from the judges. Because whatever the judges teach is law.
No, once I was telling to my interns and all from the big colleges, that is some inspiration what I derived from the seniors. I remember one matter, I was moving before the division bench of Justice Ashok Mathur and Joint officer. It was completed, Mr. Anindo Mitra was against me. I completed, I came down, I was walking down to the corridor. Then he called me and he told me, for a long time I had not seen Mr. Mitro is so much puzzled. And he patted on my back, and this kind of inspiration are always necessary from the seniors. And then the scolding also. Equal, both requires. Is which paragraph?
Paragraph 49. As noticed above.
Wait. No, this is a division bench judgment.
Yes.
49.
As noticed above.
Yes.
As noticed above, even if the authority of the state government under section 634 of the Act has to be read down in the context of such provision, then the initial provision, which class of provisions is historically of limited efficacy. The issuance of the improved notification appears justified on the basis of the constitutional authority of the state executive in respect of a matter which is not covered by any legislation, for which there is no express or implied statutory provision. So, field is open. Kindly come to paragraph.
That is the only search, whether the field is open or not.
Kindly come to paragraph 55.
55.
It is true that in ordinary course of things, it is true that in ordinary course of things, when a statute mandates something to be done in a particular manner, we have to be done in such manner that we know. But there are only a few principles which are absolute and inviolable, and most of them must be confined to those pertaining to lives of citizens. Extraordinary situations call for extraordinary measures. The Lordship is, this is an extraordinary situation. I believe your Lordship has never come across such a situation in your Lordship's career, both as a lawyer and as a judge. As long as executive actions are justiciable and the executive remains answerable to the legislature, the wide general and civil authority will actually act as the exigencies of the moment demand cannot be overstated. Only caveat being that every executive action must adhere to the constitutional spirit and not be prohibited by any law.
That's exactly what you say. No.
That's what I'm saying. But what most think this language, the only caveat, nothing else. Therefore, there is no caveat. No provision of law or constitution cause the exercise of such power. My learned engineer says, sir, without looking at the notes, you have covered everything.
Exactly, you have covered everything. That decisions I will be going through. You have explicitly explained everything in your note. Let me now, আচ্ছা এটা রাখো তো। It was my misunderstanding. I thought that really you have sought for that day only. Very well. এই যে numbers. Question 208 কি ছিল গো? ও গেছে ছাড়ো। 200 301 না দেখি কি factually I am posted very
Mr. Sengupta, therefore I am not going to repeat this point. The point is, my lord, whether in an circumstances, special circumstances, supernumerary post can be made or not. That has been factually explained to you.
So Bandhopadhyay, it will be really proper assistance to this court if I put you two questions.
Yes.
First of all, this is a cabinet decision. And pursuant to that cabinet decision, there was a direction to the School Service Commission under Section 19 of the 97 Act. How far this executive action or the legislative, whatever way, kindly explain this bridge.
Well, first of all, kindly see the cabinet decision has not been challenged before the Lord.
No.
If the cabinet decision has not yet been challenged, your lordships cannot touch that cabinet decision.
No, I cannot.
No.
Cabinet decision.
The cabinet decision remains. If the original remains on the basis of any executive order is passed, what is wrong? Because executive power is coextensive with the legislature. Let's assume today. Hey, your lordship is set as just argument's sake, these administrative directions. Correct? Let's assume. Now, my lord, I can't legislate the law. I mean, state can legislate the law on the basis of coextensive power. The law is there, but saying that the coextensive power of executing.
Mr. Banerjee, I don't think that it is required to be brought to your notice. It is not the decision. It is the decision-making process.
No.
Which is open.
No, my lord. No. Even the decision-making process of the cabinet is not under challenge, and your lordships cannot go into that questions.
Constitutional immunity.
Yes. Then if the court can interfere with the cabinet decision in every day, whole India will stall.
No, of course not. It's
No, no.
not me. It is the decision-making process.
Process means what? Here, on the basis of that, executive instruction has been issued. The state is having the power, coextensive power of the executive power in a field where law can be legislated by the Schedule 7 under List 2 by the state. The executive power is also for that Schedule 7 List 2 or the concurrent list. What is an executive power can be said to be bad? When state cannot legislate a law in respect of a different field, then the law is bad. Suppose state legislature is legislating a law in relation to list 1, then it is bad.
No, I understand.
And
But what is my query from
Hmm.
you? That the legislature, the cabinet took a decision, but while implementing that decision,
Hmm.
the executive acted in excess of that.
no, executive has not acted. My lord, kindly see what is the decision of the cabinet. So, cabinet decision, kindly come to cabinet memorandum, page koto? They have given it. The
Supplementary
underline
evidence কি? Stated. Here, petitioner is supplementary.
কোনটা আমাদের এটা পুরো কবেকার সাবমিট
এই petitioner ওদের জিজ্ঞেস করো, what is the date of your supplementary affidavit? Where the cabinet decision is a part of it. 20? No. এটা ছেলেটা ফার্স্ট ছিল খবর দিন তো নামটা কি মাদিব ছিল
This is 19th June 2000.
আজকে ছিল
Date 19th June. Petitioner.
বাঁচালো না ওকে ওই মামলাটায়
খুঁজে খুঁজে বার করাই তো মুশকিল 19 June. Now kindly read this.
19 June.
এইটা দিয়ে দেখানো তাহলে
April.
ওরা ওরা ছেলেটাকে
And you see, the Commissioner of School Education, via its proposal dated 4th May 2022, has proposed to create 16,000 number of supernumerary posts, break up 700 so and so, to absorb all waitlisted candidates.
you are reading from
Page number 3.
page number 3.
না কত? Page কত?
3 of 7. 3 of 7. At the bottom, kindly see 3 of 7. My senior is placing which
3 of 7.
yes. My senior is placing page 4. 4 of 7 top. Top.
Yes.
The Commissioner of
II.
Aye. The proposal of the Commissioner of School Education. The Commissioner of School Education, via its proposals dated, so and so has proposed to create 16 number of supernumerary posts, break up 750 work education systems to absorb all waitlisted candidates of physical and work education teacher subject to validation of the post. Right. Well, who is challenging this? Unsuccessful.
Yes, waitlisted only.
Unsuccessful. Who is challenging this? Unsuccessful persons. What is rights come in? If I let's see your lordship strike down, they will get the appointment. Court will take into all the facts. Every lapse of law doesn't call for interference by the court. That part I will give one judgment. I will give it later by junior. Every lapse of law, court is not for that reason. What is it? Here is wrong. Set aside. Article 226 court doesn't see it for that. It's a court of equity. Equity not for the petitioner even only. Equity for the others also. Read jurisdiction is not a one-way traffic. It's a double-way traffic. What the benefit you will? How he has prejudice? First question. First question, how you are prejudiced? If you have not prejudiced, no case. Your lordship is not here to decide academic questions and unnecessarily striking down the orders and unnecessarily creating the problems. Whether he will be benefited, if he is benefited, give it. Who is not prejudiced, nothing, not such. What has happened now in West Bengal? हमको खाना नहीं मिला तो किसी को खाना नहीं देंगे. Few groups are there now in Calcutta High Court.
They are talking.
19. I am rushing from this court to that court to that court to save. Going on to and continuing the matters. Bidjoy Atta. Atta. Otitto Atta. What can I do? You can't do anything in West Bengal now because of few persons. And all they have failed in every examination. I think when Justice Ganguly was there, they were very good. But thereafter, what has happened? Whole wave has been changed. When Justice Ganguly was there. But those who are getting all they are incompetent, and those who have come, they are very competent. After they have got chances, not got it. They are not getting it. Anywhere, upper primary, anywhere. Now, your lordships kindly consider first why your lordships will examine the issue at all. What benefit? Whether court will decide the question for academical reasons or court exists only to put some persons under the troubles? Is it the court's function to do it? This is not a public interest litigation. This is not a public interest litigation. Even a public interest litigation service matter, court cannot interfere. Well, this is not a case where the malpractices have been alleged. But here is the case, your lordships will not go to the OMR 6 at all. That is not the scope of the writ petition. My lord, your lordship was in the civil, your lordship know very well that pleading is an essential part of a case.
Of course.
And in support of his pleading, evidences will come. And in read jurisdiction law is, Bharat Singh's case, Bharat Singh's case, paragraph 13, just a minute. Whatever you have said in the writ petition, annexures, oppositions, annexures based on that, not a statement from the bar.
এটা তো কম্পাইলেশনটা তো
No, I am reading this. Just Bharat Singh, I will give it. আচ্ছা Bharat Singh কে দিয়েছিস এখানে দিয়েছিস it is not here, I will give it.
আমাদের কম্পাইলেশনটা
Bharat Singh টা আছে দিয়েছিস দিয়ে দিবি পরে I will give Miller Bharat just I have thought about. I am just telling you paragraph 13 losses kindly record it will be given. Two questions first come.
Citation.
88 4 SCC 534.
1988 4 SCC 534 paragraph 13. No? Paragraph 13.
Give me the compilation.
I will give it. I'll give it.
It is prepared.
In my chamber, any of the junior that time we used to enter, first I had to tell them, read fast, then come to me. I will not tell name of someone. Don't come to me for 3 days. First you read all this judgment and sit in front of me. That is I am talking about 1990.
Yes, Mr. Bhattacharya, have you prepared anything? Any compilation?
Yes, I have. But Bharat Singh is not
Yes, add it then.
there. I will add it. I will add it. Therefore, kindly, Milord, your lordships look into, but keeping in mind your lordships, there are two things. Why unnecessary exercise by this court?
According to you, all exercises have been carried out.
Futile. First question has
And this is a fact, a reality. A set of appointment has been set aside. It is a fact.
that's a different kind. Listen, that is a corruption issue. But it is not a corruption issue. Simply because one uttering the words corruption is a spicy thing now. I was arguing with Justice Chakraborty. It's a chutney. The moment says every judge is being prejudiced. In Calcutta High Court, every judge is very negative. Corruption. But corruption has to be proved. And Mr. Bhattacharya is going on saying in every court, corruption. Right? Chief Justice said to him, where is the corruption? Proved. Take your seat. And High Court judge is corruption. Corruption. Is untouchable. I may be corrupted.
Untouchable.
Yes, I may be corrupted if I touch it. If I dismiss citizen, people may say I am corrupted. No. Give it. What is this? What is this going on? I am not saying that 32,000 has been set aside. That in 26,000 Supreme Court. Supreme Court has said take examination. And when we started it, then 150 matters have been filed by these set of lawyers. And today I am having 20 matters now I have to go there.
You don't have any matter among this bunch of matters?
Huh?
No.
Because their clients will never get it. And they will not allow to get it by anybody in West Bengal. And you said, you know what has happened. You will be surprised to see. CBI has filed a charge sheet in that case for primary. 6 numbers were given to few persons illegally. And these 6 numbers, because of an order by the court and moved by the lawyers who are saying corruption. We have gone down to that stage.
Under the order of the court, 6 months.
Yes. And who has moved that? This batch of lawyers. Again, when charge sheet is filed, is arguing, see, 6 months illegally has been given. Who has secured that order? This batch of lawyers. Fantastic thing is going on, my lord, in Calcutta High Court, I can tell you. A lawyer who was moved the matter, factually argued the matter. Thereafter, he became judge. In that matter, one judgment has been given.
What are you talking about?
That judge is saying now why it will not be implemented. He has not heard the matter, judicial matter. Another matter came to him. He is saying why this judgment will not be implemented. I file affidavit in Calcutta Supreme Court. See Calcutta High Court. What is going on? There is a limit of doing these things to favor few persons. What I am saying. Tell me when you are lawyer, a fact the finance department, then measure. See proposal 2 at page
এভিডেভিটটা একবার দাও, এভিডেভিটটা আর দাও।
God can save this institution.
আরে দূর তেরি কি ভাবে
I can tell you about this. How many years I am? I have hardly 7 or 8 years of TV. Only God will save this institution. No one can save this. The pain is going on. And the way the jurisdiction is determination is made by whoever comes. Very sorry. We have to being a lawyer, I am telling all of you today. I have to think whether the judge loves white color, whether the judge loves red color, or whether the judge loves saffron color. Where is this confidence?
Yes, what point you have in this?
Come to B. To 1,000 to creation and now the Department of School Education proposes for A Roman 1,600 supernumerary posts with breakup of 7.50 works education and 850 physical education for absorbing all waitlisted candidates. Correct, man? Now your losses kindly come. Approval of the cabinet short form. 8. The proposal containing para 6 above is now placed before the cabinet for consideration and approval. Full details were there are there. Then let kindly come to cabinet decision. Cabinet decision. Cabinet decision is not. They check why is due. Cabinet decision was now that order 19 May 2020 Whereas the proposal was sent to state cabinet for including physical and work efficient teachers and non-teachers starting the performance transfer.
It is presumed it was
Now,
approved. Page 9, paragraph 8. This memo, cabinet discussion, last page, approval of the cabinet short for. It is not part of it. It is the right, but it is presumed it has must have been.
301. Read petition.
Yes.
See, 301 got it.
Mm-hmm.
Now, and whereas the state cabinet has been pleased to take decision in its 22nd meeting in treatment and accorded approval bill number 266 dated
5th May 2020.
But this decision is not under challenge. This order, whichever your lordship still, which has been interference has been called for. So what is the basic state cabinet decision? If that decision is not challenged, why your lordship still interfere? The order is bad.
No, Mr. Bandyopadhyay, power of the state to create post, I say post, is not under challenge. No one can challenge it. But the decision, how it has been implemented, the process, I want to know from you whether it is open to judicial review.
No, if the decision implementation is a procedural part. Substantive part is the
Decision.
decision. The substantive part is not challenged, why the procedural part is.
In service jurisprudence, whether
Let's come with a discussion about the law. Law is one thing that applies everything. Why that decision is not under challenge. Decision is not challenged. If it is challenged, then we can look into think whether legally, illegally, arbitrarily, capriciously, constitutionally it is correct or not.
the cabinet decision is immune under the constitution.
No.
As Mr. Shengupta is saying, and it is rightly.
Now let's assume that a cabinet decision, let's take it, I am just arguing against me. If a cabinet decision interferes with my right of Article 19(1) or Article 21, that's fine.
It is open.
Yes, no one is immune in this country. Except one. You know who?
President.
Chief Justice of India on his administrative side when he decides the cross. No one is immune. But I am not arguing to fullest extent the cabinet decision cannot be changed.
There are situations.
Well, interfere. My reading of the law, my constitutional law which I know, I tell you. No one can destroy my fundamental right. No one. Whoever it may be. Your fundamental right is violated by any decision, whether administrative, whether executive, whether legislative, whether cabinet, all are. Why not cabinet?
More precisely, a policy decision.
Policy decision, if it is based on a cabinet decision, then a policy decision is bad. Is bad. Here is an administrative order. Here is an order. right? This is under challenge, right? That's on the basis of a cabinet decision. If on the cabinet decision has to be challenged now.
Interesting.
If the cabinet decision is not challenged, but also I am saying that what I have said to you also, my mental regime, my thought of the constitution is this. Gist of the things I am telling you.
Hmm.
No one in the country, including the court, can destroy my right under the constitution, especially under the party law. It is whatever it forms. Whatever it forms, doesn't matter. Therefore, necessary question would be what fundamental rights of the petitioners have been violated that we are also. Let's assume a cabinet is taking a decision. No. From tomorrow, Calcutta High Court, lawyers will not come. Can it not challenge?
Subject to whether it is coming within the field of their such decision.
Decision, even if but decision is correct or decision is
It will be tested. It will be tested within the litmus paper of the. Hmm. That is why 162 is subject to other provision. No?
extensive provisions. That's a executive order. Executive order. This is not a, I will not, what law I know, I just said.
Yes, rightly.
It is not under article. Because it is not in the name of the law. I will not receive. I will not. This thing I have never learned, I will not. Okay. Oh, sorry.
Yes.
Now I am research. Now the order is the statutory order, not the now they are going to exercise the power conferred under section 19 of the Western the governor has been non keeping stuff. The power would be to of the Western governor is direct. We are going to leave it.
Where from you are reading?
301.
You are reading from the cabinet memo?
No.
Oh, the notice. 301.
Now, last part, the order is issued with the concurrence of the finance department. It is pursuant to the approval of the state cabinet number. It is to be approved. So these details are not necessary. Last paragraph.
And why Mr. Advocate General argued that even if it is not approved by governor, then it is not necessary that every decision of the cabinet should be approved through governor. Now, if you come to this,
What we have argued, I am not going to argue that part because I am not.
it is not. It is there.
I am not.
Mr. Bandhavada, please come to page 3, the notification, rather the cabinet decision, discussion. Are you getting anywhere that it was approved by governor? This No, that notification is right. Are you suggesting
Governor has not required to sign.
with the approval of the government?
Not required, approved by the governor.
No, not necessary. If you come to page 9, approval of the cabinet short for. Approval of the cabinet short for. If you kindly see once, proposal of cabinet in para 6 have now been placed before the cabinet. And the
Approval of the cabinet
short for.
Yes.
Therefore, the cabinet approved, as you have read out, approved. In between, whether this approval was routed through governor.
Approval is not needed, not.
It was factually, because the notification says with the approval of the governor.
No, that is.
3-1, that one.
And see, that is in exercise of governor.
Please to create.
Governor is to create. Now taking this.
For that reason, it is need not be placed before the governor.
No, I don't think so. Or governor is required to be consulted or not, I don't know. Whether that allegations are there.
No, I need to know that. The route. What is the route? Because as you.
Have come. It needs to be clear. So 166 of the constitution.
I will not engage for a long time. Please consider.
Or kindly see 166.
Hmm.
Clear. All executive action of the government of a state shall be expressed to be taken in the name of the government. If it is in the name of the government, 166 is satisfied.
For that reason, no.
Second, it will be clear. Order and instruction made and executed in the name of the government shall be authenticated in such manner as may be specified in rules to be made by the government. There's a rule. There's a rule which is called business rules of business. And others are not called in course on the ground that it is not an order or instrument made or executed by the government. The governor shall make rules for the more convenient transaction of the business of the government of the state and for the allocation among ministers of the state to.
So it is not open to
No,
challenge.
it is a business rules have provided and business rule is existing. Time to time it is being amended. But it is not needed that every time it is ready to go.
Not necessary. That exactly Mr. Dotto argued.
That take it in. Honorable judge will take course. That has gone to the government.
There are rules will provide which is to be gone to the government. Exactly that Mr. Dotto argued in that line.
Now let us kindly see. This is not challenged. Even if it is challenged, why it is bad? This is why it is bad. Now, what is the normal? Normal rule is that after expiration of panel, no one gets. Whether existing or new, it is normal. Suppose my name has waitlisted, panel has expired. I am saying coming to your lordship for your lordship, no, you are don't have a right. But can the government is not in a position who can legislate the law, who is having a power to make a special class to make this waitlist? Not a single man, all the waitlist. What is the harm on that? Is it taking it? Anybody's? I can understand a case, but let me tell you, I can understand a case that not these persons, but new persons who may get the chance, may got the chance, have they not been appointed in that case? Our right is being taken away. And what is supernumerary post? Supernumerary post is, my lord, is a temporary one. When vacancy will be created, they will be adjusted again. And for creation of an adjustment, they don't get enjoyed seniority. Right? There were who could have challenged it. Aspiring candidate to be appointed.
Or the similarly placed candidates who are already in employment.
No, not the employment has no right.
Supernumerary.
Judgment is there. Let's assume, my lord, X has got the employment, on the basis of panel pass. I am in the wait list. Right? Super and universal post have been created. I am a temporary one. Let's assume. In the meantime, another advertisement has been. Other persons have come. Correct? Now, supernumerary post persons are being regularly appointed. So, ABC case. Although I was B, C has come. B seniority will be counted after C.
That was the effect of this
That is it.
appointment.
Until the trace post comes in, they cannot be adjusted.
The last question to you. Whether this is a part of 2016 selection process? 2016 selection process?
So first part.
This one. There was a selection process. No, I'm not talking about 9, 10, 11, 12, Group C, Group D. For upper primary selection process 2016, this creation is a part of that selection. Then first understand the question, then guide your senior. 2016, there are two separate 9, 10, 11, 12, Group C, Group D, we are not concerned about. A selection process for upper primary level of schools. Within this, another thing, work education, physical education. I want to put you a question whether this work education and physical education is a part of 2016 selection process of upper primary classes of schools.
No.
Then it is a new selection.
No. Selections was also separate selections.
For upper primary.
No. For what? Physical education.
It has no connection with the upper primary. No. Sir, upper primary level of schools, there was a selection process in 2016 by virtue of a employment notification. Within this same employment notification, assistant teachers for the classes up to class 8. Up to class 8. And work education, physical education teacher for that class. It is under the same advertisement or not?
Advertisement separate. That is a 10% quota.
Primary schools were there, covering everything. Selection was conducted separately for normal and upper primary for work education.
But by two separate appointment notification or the single?
Two separate.
But under the same rules.
Under the same criteria.
Therefore, 2016 same rule applies to this all.
Yes, rules apply for.
That's all.
But good question. Since they have not, good question would be whether these persons were related to any Quran practice. Entire panel has been appointed.
It was argued to meet the agitation in the street. These posts have been created.
Yes. Because you and try work. Government has to ask. I am not appealing for the state now. Government has
You may not, but you cannot remove your jacket. Represented.
government has to take action.
Now it's decision গুলো দাও।
10 years there was no selection. The 2 or 3 judges
Just give me this bunch.
because I am giving it to you also. Can you note down?
And yes, yes, that is there, I think. Where is the compilation? Give it. Then, this again, Mr. Rahul, you did not do it. You have not done justice to your name. Give me an index for which point you are, on which point you are giving it, like the other one. He doesn't have that time. Your dad junior has not that much time.
He is my now teach at my good age.
No, I appreciate he is sustaining you.
Yes, yes.
No one is there to
No,
young.
this
Of course. Why are you just making this credit in your favor? Don't try to. Don't try to. Mr. Rahul, please do it with the paragraph number and the proposition on which your senior is citing this. And this one I'm keeping, I understand. The AI.
I will give it in the notice, sir. There's no
Just give it in a note. I got your crux of your argument. Yeah. এটা
2011 6 SSC 59, sir. 130. Up to 130. And to paragraph 18.
Paragraph
18. Page 142. As rightly pointed out by Mr. Altaf Ahmed, without any arguments having been made, or without there being any question raised by any person as to the validity of the cabinet decision is concerned, and without the same being a question or any relief sought for in the issue, the High Court has gone into the state decision of the cabinet having taken place after the judgment was the decision of the cabinet general or not to be interfered with the judicial review so lightly as has been done in the present case. The causing of the cabinet decision without analysis of pros and cons matters is to restrict the state's constitutional authority. But the order outfall of the cabinet, nothing more than that.
So in the absence of the follow-up actions cannot be. Mr. Rahul, I have to give it to you.
Yes,
Please. We can do it today. Just press it and give it. হ্যাঁ দিয়ে দাও একসাথে করে দেবে চাই দেখো তো rush to the another court.
Become mad. No one will allow to continue with the process.
The new selection. This is a new selection test.
Redundant. Anyhow, just restored. I have to give explanation every day that whenever Justice Sanjay Mr. Bandopal, we will hear from him. Don't go whether it is not done. See my problem.
Examination is over.
Okay, result has been declared.
No, there is no injunction, I suppose.
Every matter. Give this 5 marks, give this 10 marks, give this is the way.
Mr. Bandopal, why are you criticizing? Everyone is aspiring for the job, the only government job available. Once I told you that it is for giving.
When issues are pending,
Not to touch. Maybe collaterally, that is why this matter, একটু বন্ধ করো তো।
2011. These are the sections that I had already placed. Then National Council for Teachers Education Act 1993.
That you have explained.
That was also done. Then Lord, please come to paragraph 6. This is the rules prescribed by the West Bengal School Service Commission for appointment to the post of teachers in West Bengal in 2007, 15 and 16. Lord, I had shown that in 2007, the qualification, the B.Ed was actually a desirable qualification. Then Lord, in 2015, it was a desirable qualification. But 2016, Lord, B.Ed became mandatory qualification. And D, there are several notifications published thereafter by Director of School Education, memo number such and such, stipulates that the school authorities would allow all untrained teachers of class 5 to 12 to take admission in B.Ed course on deputation. Then, Lord, before that, Lord, I just wanted to add one sentence here. Lord, reading these rules and the circulars, Lord, one thing would become clear to your Lordship, that there was not an intention, there was no intention, Lord, to take away the jobs of the existing teachers. The intention was that to make them more qualified. The purpose of bringing in this as a mandatory, Lord,
Not like that, the recent judgment that if you don't have the TET qualified candidates, their job will go.
that is
was
Lord,
not.
no, that was on a different consideration.
No,
Because
therefore, according to you, this was for the enhancement of the teaching quality.
at this stage, it was only for the enhancement of the qualification of a teacher. That was the purpose. So the purpose was not to take away the job, but it was introduced as a mandatory measure to enhance the quality or the educational standard of a teacher. Then, Lord, peculiar facts and circumstances in GTA, which I have, Lord, placed from the West Bengal published documents. Your Lordships will kindly see that as a result of the agitation, the normal life came to a standstill. And that was one of the reasons why, Lord, this delegation of power and other things were conceived.
And you have given one
Booklet. Booklet published by the state government.
Two booklets.
In 2 volumes. The booklet is in 2 volumes. This is, Lord, reproduction of what I argued. I am not, Lord, repeating what I have said. And then, Lord, this is next heading is sequel of events leading to
that the new school has come, no requirement, no new recruitment, and that was the situation which actually that has prompted the GTA to take this kind of.
And Lord, the Public Service Commission, they had closed their office. And Lord, since 1997, there has been no recruitment. And Lord, post this declaration of
new schools have been upgraded. These are the sequel which actually prompted the GTA to take such a decision.
I tell you, Lordship, GTM, Lord, approached the state government.
Yes. In supersession of their earlier decision.
In supersession, no, Lord, their decision was not to recruit teachers further and as an ad hoc measure, because these are volunteer teachers or ad hoc teachers. That was the decision. But Lord, they approached the state government for regularizing these teachers because recruitment was not possible at that stage. Lord, the School Service Commission was.
Are you suggesting that in between your earlier decision not to recruit any voluntary teacher and ultimate Gorkha Council's decision in supersession of earlier decision regularization, in between no new appointment was made in the voluntary
I'm
teachers?
not saying that. What I'm saying is that decision of the GTA not to appoint any further volunteer teachers, that stood superseded. Number one. Number two is that in the meantime, GTA, Lord, also approached the state government saying that there are number of voluntary teachers who are, Lord, manning these schools, which were in a situation where they are unable to, not sufficiently equipped teachers are there for the purpose of giving education. So, Lord, there was an approach to the state government. I will take your Lordships to only that part today, where, Lord, the approach to the state government and how the state government took note of the lack of teachers, lack of teaching facilities, and at the same time, the mandatory requirement, because my lord, the administration of parting education had gone to GTA. The administration of parting education, the obligation, the constitutional obligations, statutory obligations were already with GTA. But Lord,
Under the statute or under the agreement?
under the agreement as well as under the statute, because under the agreement, the assignment or the delegation had taken place. Delegation of the transfer, the transfer had taken place under the act itself. Your Lordship remembers 2011 Act, Lord, records the delegation, that what are the departments which are handed over. So, Lord, the post delegation, the concept was that they will run the administration, they will Lord, teach the students, they will Lord, impart education. But Lord, point remained that they were unable to do this. Number of schools increased, and these temporary teachers, whatever little temporary teachers were there, this was 400 and something, and then 330, total 700 something. They were managing the school. The vacancies were more than 3,000. So, my lord, this is the situation where an approach was made to the government that please regularize these teachers, these 700 and odd, first, my lord, 400 and odd, and then, my lord, the subsequent request. I'll just take your lordships to this chapter, that how this policy decision was made by the government, Lord, by placing it in the cabinet and then following it up. I'll just take your lordships.
313 never placed in.
No, 313 was not, because 313, I'll show your lordship, 313 was similarly placed as 400 and odd.
You're as if left out.
Yes, because the policy decision was to be on the basis that these teachers, the volunteer teachers, should be regularized. That was the discussion between GTA and government, which is recorded in a minutes. And Lord, this followed with the decision of the cabinet. The cabinet decision came at a point of time, this as a policy decision, that 400 and odd should be regularized. Then, Lord, it was pointed out to the state government that this 400 and odd was not there. Further people are there who are similarly circumstanced. So, Lord, the matter was again re-verified, and this 313 figure came. And post that verification, 313 people were also regularized. I just, Lord, want to show this part to your lordships factually. If your lordships kindly...
Actually, you have demonstrated it, but what I want to know from you,
yes,
that there was no cabinet decision. What is actually, lastly, we were that the state's affidavit.
Lord, I'll first, Lord, kindly take
Mr. Kumar, can we continue at 2 p.m. or tomorrow? Sorry, Monday.
Monday, Lord, 2 p.m. I have some difficulty, but
Morning. $11 o'clock.
Lord, show Lord 4 or 5 documents in sequence, and Lord, I'll show Lord how this policy decision was taken, that they should be regularized. And Lord, whether next question would be whether it infringes Article 14, Lord.
Yes, as argued by Mr.
Because he has relied heavily on Uma Devi and 2 other judgments.
Exactly.
Where I will cite, Lord, the judgment of the Supreme Court. Lord,
that has been quoted over here, I think.
No, I don't think that is quoted. I'll, Lord, give the judgment, Lord, to your lordship. No, I don't think it was.
What is the use of it? Chasing me up to Andaman?
No, the other judgments are there. The other judgments are there because, Lord, I'll also have to deal with the stand.
It must be complete. You have chased me up to Andaman. What is the use of it?
That is the result of Lord, subsequent research.
These are
discovery, subsequent discovery.
Every day, Lord, new things are happening. This is
you are giving that.
No, I tell you, Lordship, Lord, I am not being able to give the full time at a stretch. Therefore, Lord,
let you conclude it by this weekend.
Yes,
give it to
me. I know, I will. But just one judgment is left out. Otherwise, the note is absolutely fine. That is, I
have already read it. That is why.
No, I will not change anything in this note. Lord, only Lord, the one judgment I'll.
ওটাও আছে নাকি?
Can I suggest something? Give me time from 12 up to 1:30. I'll try and
No, they are also in the queue. I will not give them 15 minutes over. So accommodate one before.
Lord, let me, Lord,
Oh, there he did not argue. You are allotted time is there. You have taken a very interesting point. That is why on 15 minutes is over.
I come back at 11. I don't mind. In case your lordship has fixed other,
No.
I'll come back at 11.
That is 10 minutes allotted to Mr. Chaudhary. All is over. SSC to bole diyeche to. In this matter, SSC will say something. SSC, what SSC will say?
Department concerns the SSC.
Yeah, that is the in GTA matter. SSC has got. এটা রেখে দাও তো আপনি কাজ